Let's go with Article 1175. The usurious transactions shall be governed by special laws. Wherein usury, as we all know that usury law has been suspended, diba? It is, usury means contracting for or receiving something in excess. It's contracting for or receiving something in excess of the amount allowed by law for the loan or use of money, goods, chattels, or credits. It's receiving something in excess of the amount allowed by law for loan, use of money, chattels, credits. Kinds of interest. Interest given for compensation or the use of money, also called by some authors as moratory. Moratory interest or the use of the money. Interest given for compensation or use of money. That is, I borrowed 1 million pesos at 8% interest per annum for 3 years. So this is a kind of interest regulated by usury law. There can also be a usury given by way of damages. Diba? By way of damages, also referred to as by some author as compensatory interest. So when it comes to the use of money, it's moratory interest, while by way of damages, interest by way of damages, it's the compensatory interest. Next, I borrowed 1 million pesos with no interest for 3 years. If I pay at the end of the 3 years, I pay no interest. If I incur default or do not pay even after demand, I will now be responsible for interest by way of damages at the rate of 6% per annum to be counted from default. So today, usury law has been repealed by Central Bank, now Bangko Sentral, Circular 905, effective January 1, 1983. So those are interest. So what's the difference between lawful rates and legal rates? When it comes to lawful rates, it is the authorized rates, those allowed as maximum under the former usury law. So it is 12% per annum. 12% per annum. That is under usury law. When it comes to lawful rates, authorized rates, it's 12% per annum. If secured in whole or in part by a mortgage upon real estate, if the title to the real estate is duly recorded, or by any document conveying such real estate, also registered estate. So whole or in part of a mortgage upon real estate, title to the real estate duly recorded, or by any document conveying such real estate, so or an interest therein. In another, if it is secured, again 12% per annum if it is secured in whole or in part of a mortgage. What if it is not secured? If not secured provided by usury law, it is 14% per annum. If secured by a mortgage upon real estate or upon a title of the estate, it's 12%. But if the loan is not secured, then 14% per annum. While legal rate that presumed by the law to have been agreed upon if the loan mentions interest but no rate was stipulated. So this is to be used 6% per annum. Now it is 12% per annum as directed by the central bank or Bangko Sentral Circular. No interest by way of compensation for its use will be given in case it is not expressly stipulated in writing. So when it comes to legal rate, it is 12% per annum. If the loan mentions an interest but there is no interest, but there was no interest rate was stipulated, then it will apply the legal rate. Legal rate, which is 12% per annum. So that this time, let's go to Article 1176. Article 1176, wherein the receipt of the principal by the creditor without reservation with respect to the interest shall give rise to the presumption that said interest has been paid. The receipt of a later installment of a debt without reservation as to prior installment shall likewise raise the presumption such installments have been paid. So example, how is this? How is this Article 1176? Wherein the receipt of the principal by the creditor, receipt of the principal by the creditor without reservation with respect to the interest shall give rise to the presumption that said interest has been paid, and the receipt of the later installment of a debt without reservation as to prior installment, and shall likewise rise the presumption that such installment had have been paid. So example, for paragraph 1, wherein receipt of principal without reservation as to interest. Receipt of principal, this is now receipt of principal without reservation as to interest. A creditor of 1 million with 8% interest received 1 million in payment of the principal. Again, a creditor of 1 million with interest of 8% interest received 1 million in payment of the principal. Interest was not referred to in the payment. It is presumed that 8% interest had already been previously paid. It is presumed that 8% interest had already been previously paid. This is because under Article 1253 of the Civil Code, payment of interest as a rule precedes payment of the principal. It means to say, pay first the principal, then that's the time you will pay also the interest. So, because under Civil Code 1256, it's the payment of interest precedes. It means to say, subsequent to payment of the principal is the interest. Of course, Article 1176 establishes a mere rebuttal, not a conclusive presumption. This is under Hill versus Veloso. Thus, even if there is a receipt evidencing payment of the principal, the accumulated interest may certain cases be still recovered. So, even there is a receipt of evidencing payment of the principal, the accumulated interest may certain still be considered. Okay? That's why the receipt of the principal by the creditor, the payment of the principal amount to the creditor without reservation with respect to the interest shall give rise to the presumption that said interest has been paid without reservation. For paragraph 2, wherein receipt of a later installment. For paragraph 1, it's the receipt of principal without reservation as to interest. So, if there is receipt already, there is already payment of the principal amount to the creditor without reservation as to interest, no reservation, it is already presumed that the said interest has been paid. So, there is a need of preservation. Because after payment of the capital amount of the principal amount, then therefore, there will be an accumulated interest in certain cases be recovered. Next, for paragraph 2, example of paragraph 2, receipt of later installment. If a creditor receives the fourth installment of a debt, if a creditor receives the fourth installment of a debt, it is understood that the first three installment had been paid. Diba? If the creditor receives the fourth installment of a debt, it is understood that the first three installment had been paid. So this is a similar situation with paragraph 1 of Article 1176, wherein the payment of the principal amount to the creditor without reservation of the interest, such interest is presumed to have been paid. Without reservation as to the interest, diba? Without reservation as to interest. The same thing here, receipt of a later installment presumes that the prior installment had been paid. The receipt of a later installment of a debt without reservation as to prior installment shall likewise rise the presumption that such installment have been paid. It means to say the receipt or the payment of the fourth installment without reservation as to the prior installment, without reservation as to the prior installment payment, it is presumed that the first three installment had been paid already. The same also with paragraph 1. If there is payment of the principal amount without reservation as to the interest, then therefore the interest is presumed to have been paid. That's under Article 1176. Next, this is now Article 1177. Article 1177, the creditors. The creditors have, after having pursued the property in possession of the debtor to satisfy their claims, may exercise all the rights and bring all the actions of the latter for the same purpose, save those which are inherent in his person. They may also impugn the acts which the debtor may have done to defraud them. So this is a review already wherein the rights of the creditor. This is the rights of the creditor. The creditors after having pursued the property in possession of the debtor. After having pursued the property of the possession of the debtor to satisfy their claims, may exercise all the rights and bring all the actions of the latter for the same purpose, save those which are inherent in his person. It means to say, there is an action subrogaria, wherein that the creditor is already in the foot or feet with the feet of the debtor, and that creditor becomes in the rights of the debtor becomes the right of the creditor. So it is now the creditor may bring all the actions of the debtor for the same purpose, to satisfy the debts of the debtor to the creditor, except those inherent in his person, except those inherent to the debtor, such as the legitimes of the debtor, inheritance from the debtor, or those inherent persons inherent in his person. So as a summary, wherein these are the rights of the creditor: exact payment, right to exact payment, exhaust debtor's properties, generally by attachment, except properties exempted by law, so such as legitimes, diba? Exact right to the exact payment, right to attach or exhaust debtor's properties, actions subrogaria or subrogatory actions, exercise all rights and actions except those inherent in the person, like parental authority. As a general rule, in subrogatory action, wherein exercise all rights and actions, the creditor can exercise all rights. All rights and actions can be exercised by the debtor. The creditor becomes in the right of the debtor. In every rights, the creditor can exercise all rights and actions of a debtor except inherent in his person, such as except those inherent in the person. where parental authority, inherent in his person, parental authority, right to revoke donations on the ground of ingratitude, hold office, carry out an agency. This is not a remedy of subrogation referred to in the chapter of novation. So we will just go with novation. So again, action subrogaria, action subrogaria, this is not remedy of subrogation. Action subrogaria wherein the creditor is now in the foot or in the feet rather. The creditor is now in the feet of the debtor. All the rights and actions of the debtor can now be exercised by the creditor, except those inherent in the person. Parental authority, right to revoke donations on the ground of ingratitude, right to hold office, carry out an agency. That is for action subrogaria or subrogatory action. And the next one is that action pauliana. Action pauliana, it's to impugn or rescind acts or contracts done by the debtor or to defraud the creditors. Action pauliana, it's to impugn or attack or rescind acts or contracts done by the debtor to defraud the creditors. Action pauliana, it's to impugn or rescind contracts, acts done by the debtor to defraud the creditors. That's the difference between action subrogatoria and action pauliana. In action subrogatoria, the creditor is now in the feet of the debtor, can exercise all rights and actions except those inherent in his person, such as parental authority, right to refuse or right to revoke donations on the ground of ingratitude, hold office, and right to contract with agency. And while in action publicana, it's to assail, it's to impugn or rescind an act or contracts done by the debtor to defraud the creditors. So let's take an example, a case. A was a defendant in a civil case. He lost an attachment was issued against his property. B, the winner, could not collect his claim because it was discovered that A had sold his warehouse to his son C. After attachment had been issued on such property. So B is the winning party, attaches the property of A, and B discovered that the properties of A were already sold to the son, to A's son. B, who could not collect in any other way because A had no money, brought an action to rescind the contract allegedly made to defraud him. It was proved that although the warehouse was worth 25,000 pesos, the son allegedly paid only 15,000 pesos for it. The son probably did not have the 15,000 pesos or any other sum of importance with which to buy the said warehouse. The Supreme Court ruled the transaction is fraudulent since B, the creditor, cannot recover in any other way. The contract ought to be rescinded. This is an example of action pauliana, wherein the transaction is fraud. So therefore, the creditor is entitled to rescind that contract. So again here, A was a defendant in a civil case, lost an attachment to his property, was ordered by the court. Against his property was ordered by the court. B could not collect his claim. B, the winner, could not collect his claim because it was discovered that A sold already his warehouse to his son C after attachment had been issued on such property. So here there is fraud made by A. A is already guilty of non-payment. In order to avoid attachment ordered by the court in favor of the winner, A sold the warehouse property to his son C, so that B, the winner party, could not collect against A. So the remedy of B is to rescind, is to file an action Pauliana. Again, the remedy of B is to file an action Pauliana against C, against A, to rescind the contract, of sale. Diba? A is the losing party, and an attachment order will be placed on the property of A in order to avoid attachment by the court in favor of B, the creditor or the winning party. A sold the property to C. So there is a contract of sale. That contract of sale between A and C is a fraudulent transaction. So therefore, the remedy of B is to file a rescission on the contract of sale between A and C. That is action Pauliana. So last, we're in examples of rights inherent in the person of the debtor and which therefore cannot be exercised by the creditors. As we all know, parental authority, right to revoke donations on the ground of ingratitude, right to hold office, and right to contract with agency. So these are additional examples which cannot be exercised by the creditors. The right to exercise thereby exempting from the reach of creditors whatever he may be receiving as support. So support, rights or relations of a public character, positions, rights of an honorary character, rights pertaining to the affairs of the home and family, or rights pertaining to the affairs of the home and family, personal rights as husband and wife. So parental authority and also personal rights of husband and wife. Rights granted by law only to the debtor, such as action to revoke donation on the ground of ingratitude. And right to appear in court proceedings like settlement of an estate. So those are rights that cannot be exercised by the creditor because it is inherent in his person. Next, as a review of family code, properties exempt from exemption or properties except as otherwise expressly provided by law, the following property and no other shall be exempt from execution. Properties exempt from execution. These are the obligor's family home, the judgment obligor's family home, their family home as provided by the law, or homestead in which he resides, the homestead, and the land necessarily used in connected with. So these are exempted from execution. The judgment obligor's home, family home, the homestead, and the land necessarily used in connection therewith. Ordinary tools, implements personally used by him in his trade, employment, or livelihood. Ang ordinary tools for his trade, employment, or livelihood. So these are all under Section 13 of Rule 39 of the revised civil procedure. Section 13 of Rule 39 of the civil procedure. Properties exempt from execution. These commonly the judgment obligor's family home, homestead, and the land necessarily used therewith. Mga ordinary tools used in his trade or employment or livelihood, house furnitures, utensils necessary for housekeeping, Provisions for individual or family use sufficient for 4 months. Yes, the provision, the foods that will be used for 4 months, the professional libraries and equipments of judges, who one fishing boat and accessories not exceeding the total value of 100,000 pesos by a fisherman. So those are under section 13 of the rule 39. Lastly, Article 1178, subject to the laws, all rights acquired. Subject to the laws, all rights acquired in virtue of an obligation are transmissible. All rights acquired in virtue of an obligation, from an obligation, if there has been no stipulation to the contrary. So therefore, all rights acquired, it should be all rights acquired. All rights acquired in virtue of an obligation are transmissible, but subject to the law. Subject to the laws, all rights acquired in virtue of an obligation are transmissible if there is no stipulation to the contrary. That's the general rule. Rights are transmissible from an obligation, except if the law provides there otherwise, if the contract provides otherwise, and if the obligation is purely personal. That's it. Article 1178. As a general rule, all rights are transmissible arising from an obligation, except those expressly, except when the law expressly provides, except when the contract provides otherwise, and if the obligation is purely personal.